Good afternoon.
Good afternoon, Miss Allen. How are you today?
We're making it work.
Okay, good. Glad to hear it.
Good answer. I'm gonna have to use that one.
Miss Grace, are you with me?
Yes, sir.
Can you see what's taking where courtroom two is
They're
for me?
coming in right
All
now.
over there now.
Okay, thank you. All right, good afternoon, courtroom two. Are we ready to begin?
Yes, we are.
All right, very good. Good afternoon, ladies and gentlemen. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. We're providing you with the assistance of a public defender this afternoon if you choose to utilize their service. Who do we have first?
First, we have position number one. Well, I'm not sure if he's position number one, Mr. Allen. I don't have the calendar in front of me right now.
Oh,
One and
okay,
two.
this is Dartavius Allen. Good afternoon, Mr. Allen.
Yep.
You've been charged in case 25 CR 001704D with theft by conversion, and in case 25 CR 001705D with theft by shoplifting. Good afternoon, Mr. Howard. Is there a history?
I got 8 total. 2022 probation, 2015 uh possession of alcohol below legal age conviction, 2012 burglary, theft by taker.
Thank you. Good afternoon, Mr. Sirocco.
Good afternoon, Judge. So for this first case, the theft by conversion, this incident took place on September 20th of last year at 1955 Enon Pines Drive, Southwest Atlanta. The defendant worked for the victim in this case, Thaddeus Lee, worked for his lawn care business, which operates out of that location. Defendant was entrusted with a leaf blower valued at $750, which was to be used for said business. After Mr. Lee requested that the defendant return the blower, defendant did not do so. On the second case, it's a theft by shoplifting. That incident took place March 30th. So 2 days ago, 2025, at 4735 Jonesboro Road in Union City. It's the Walmart there. Law enforcement responded to a shoplifting call and met with loss prevention manager Deborah Buffin, Buffin, who explained the defendant was spotted leaving the store with a grocery cart containing items that were not paid for, passing all points of sale. Defendant was already detained on scene by another UCPD officer after he had attempted to walk out of the store with various household and personal items valued at $138 roughly. As Mr. Harris stated, previous convictions for burglary, theft by receiving arrest, 2017, that wasn't prosecuted. Aggravated assault conviction, 2018. But there's a number of probation violation arrests, 2012, 2014, 2015, 2018, 2023, and the latest in 2025 with an FDA in 2012, excuse me. Given the history and the nature of the offenses, the state is seeking for the first case a $1,000 good bond, no further contact with Thaddeus Lee, that's Thaddeus, Lee, stay away from 1955 Enon Pines Drive, Southwest Atlanta, and no drugs, weapons, or alcohol. And for the second case, the theft by shoplifting, state is looking for a $1,000 good bond on that as well. Stay away from all Walmart premises and property. No drugs, weapons, or alcohol while out on bond. Thank you.
Okay, Mr. Chatai?
Yes, this is my case, Judge. I asked this court to consider the possibility of a signature bond, otherwise the lowest surety amount possible. My client is a lifelong resident of Georgia. In terms of schooling, he got his GED, and most recently he has worked at Hartsfield-Jackson International Airport, and he was there in a customer service role, and he's been there for a couple of months now. I looked over his public safety assessment report, and I did not see any violent convictions or FTAs. In terms of the FTA, the state did mention that was back in 2012. So it's been, so since that was a long time ago, I would argue that Mr. Allen is not a flight risk. So I asked the court to consider a signature bond.
There was an aggravated assault 2018.
Okay, for the theft by conversion, $1,000 signature bond through pretrial level 2. No further contact with Mr. Lee. Stay away from the Enon's Pine Drive address. No drugs, alcohol, weapons while out on bond. For the theft by shoplifting, $1,000 signature bond through pretrial level 2. Stay away from the Walmart on Jonesboro Road. No drugs, alcohol, weapons while out on bond. I'm going to let you out, Mr. Allen, but if you don't show up for your next court date, they're going to put a warrant out for you, okay? Good luck to you, sir. Who do we have next? Mute courtroom 2.
I'm sorry, I'm not sure of her position, but, Ms. McGurk.
That's
11.
Thank you. Position number 11, Christine McGurk. Good afternoon, Ms. McGurk. You have been charged in case 25 CR 001702J with theft by shoplifting and willful obstruction of law enforcement officers. Is there a history, Mr. Howard?
It's a 9th arrest. She's on probation for burglary. 22 SC 185089. Got an open battery, 2 counts, trespass in state court. It's 24 CR 006358J. 2024 probation. 2022 reckless conduct, first offender. 2022 battery, DV dismissed.
Thank you, Ms. Allen.
Thank you, Your Honor. This is an incident from yesterday, the 31st of March, at the Nordstrom Rack in Alpharetta at 6200 North Point Parkway. Officers there arrived to Nordstrom where they spoke to loss prevention. Loss prevention was struggling with the defendant who they had detained for shoplifting. She was pulling away, flailing in her arms and yanking and being disruptive there. That's the obstruction. She was given verbal commands to stop. She did not. Eventually, she tried to run after she got a hand loose from the handcuffs. Other officers had to help assist getting her into control. In her possession, or she tried to take multiple items, Your Honor, sneakers, handbags, etc., multiple items of household and clothing. You did just hear that she's got an open case right now. She was in custody in front of Your Honor, has a $2,000 or $5,000 SOB through pretrial level 2. From September of 2024 on 24 CR 006358J. That's a criminal trespass and a battery that's open. We're asking for a $2,000 surety to stay away from the 6200 North Point Parkway, the North Point Mall. No drugs, alcohol, or weapons, and an anti-theft course. Thank you.
Mr. McClain, good afternoon.
Good afternoon, Your Honor. Thank you. Christine McGurk is a graduate of KSU with an Associate of Arts and Science. She works at a bank doing guest services. Your Honor, she has a good address. It's the same as she had last fall when we saw her last. Um, the request from our viewpoint would be to ask for a signature bond again. And if not, then a $1,000 surety bond. Thank you.
Okay, Ms. McGurk, since you've been before me before and I gave you a signature bond previously, I'm not willing to give you a signature bond again. As such, it's going to be a $500 good bond per charge, which makes for a total of $1,000 good bond. Stay away from Nordstrom Rack on North Point Parkway. No drugs, alcohol, weapons while out on bond. Good luck to you, ma'am.
Next we'll go with, Ms. McGriff. I'm not sure of the position number.
Anastasia McGriff is position 10.
It's a 10.
Okay, good afternoon, Ms. McGriff. You've been charged in case 25 CR 001712A with battery. Is there a history, Mr. Howard?
Second, 2021 DUI conviction.
Yes, Ms. Allen.
Thank you, Your Honor. 1 second. This is an incident from the 31st, so yesterday. The location is 1246 Allen. It's Allene Avenue Southwest. The victim in this case is Jonathan Ashman. Police were called to the location regarding a domestic. They spoke with the defendant, Mrs. McGriff, in reference to a dispute with her and her partner. She said she went through Mr. Ashman's phone, saw he was planning to fly someone out to see him. She was getting ready to leave and take her son to Alabama, and she confronted him. He then took her phone and punched her in the leg. When police spoke to the victim, Mr. Ashman, he told police that the defendant woke him up out of his sleep, said that he'd called 911 about someone going through his phone, and he was supposed to meet up with them. He said that the defendant threw the phone at him and got on top of him and injured him. He had injuries on his left shoulder and the top of his neck. And he reported that he had to fight off the defendant in order to leave the location and ask for help. We did speak to Mr. Ashman today. He says they're in a relationship, that the defendant in front of you is currently 5 months pregnant. He confirmed what had just happened and said that this is the first time and he's not in fear. We're recommending a $3,000 SOB through pretrial to stay away from 1246 Allen Avenue Southwest.
Hello, ma'am.
Excuse me, one moment.
Hold on, sir. I'm gonna let you speak, but you cannot
sorry.
interrupt on my
I'm
court,
sorry.
okay?
I'm
You're
sorry.
welcome.
Won't
Okay,
happen
I
again.
accept-
Sorry.
I accept your apology, sir. I'll be with you, okay? All right, I apologize, Miss Allen. You can go ahead.
We are also requesting no further contact, no drugs, alcohol, or weapons, and a one-time escort. The vulnerability of the defendant in her current position, and being pregnant, and the fact that both of these individuals responded violently during this incident is concerning. Thank you, Your Honor. If you'd call for Mr. Ashman, obviously, thank you.
Okay, and is that Mr. Ashman under Jonathan's iPhone here?
Oh, yes, sir. How you doing?
Okay, I'm doing well, sir. If you'd like to address the court, I'm happy to give you that opportunity. I need for you to raise your right hand for me. Do you swear affirm the testimony you're about to give before this court would be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. What would you like to tell the court?
Yes. I would not like to have the solid bond.
Okay, what can you tell me about
And-
the incident, sir?
Like I said, I was confronted. Things got out in a sprawl. I then grabbed all my stuff and left the house. I then got a text message from her, and then I called police and notified exactly what the situation was going on. I stayed there, and I waited for the police to come until we got everything disputed. But like I said, I would not like to. I would like to. Something has to work out between us about this whole situation. We're coming off with she can't live at the property. I don't know what's gonna happen. I'm in fear. I need to see my child. is killing me. I haven't slept. I don't know. Quite frankly, I'm still overwhelmed that this even happened. It even got to this extent to put each other's livelihood in this fear. She could be there and I won't be there. I'll give her the apartment if she wants it. She can have it. I'll pay for it. And she could be there and I won't be there. But she has to come home and deal with all her stuff, if possible, Your Honor.
Has this ever happened
And
before?
I'm the one that's gonna be putting the money up.
Okay, has this ever happened before?
No. Like I said, she's 5 months pregnant. All this is going on. I'm just overwhelmed right now. We just need space and
Okay.
therapy, and nothing like this could ever happen again.
Okay, well, I'm gonna give you some space for right now, okay? All right, thank you for being here this afternoon, sir.
And I would like to say, I'm gonna pay for the bond. I don't know how you guys do it. Do I come down right
Hey,
now?
you don't have to worry about that, sir. Don't worry about that right now. The state has suggested a signature bond, so no one's gonna have to put up any money if I go along with what they're requesting, okay?
Thank you so much, sir.
All right. Yes, Mr. McLean.
Your Honor, without going into her background, I'm just going to agree with the state on the signature bond and ask and defer to the court for appropriate conditions. Thank you.
So it will be a $2,000 signature bond through pretrial level 1. At this point in time, no further contact with Mr. Ashman. Mr. Ashman says that he's not going to be at the incident location address, so I'll give her a one-time escort. If Mr. Ashman is not there, she'll be allowed to stay there. If he is there, she'll have to get her belongings and go somewhere else. No drugs, alcohol, weapons while out on bond. Let me explain to both of you all, since I have you here. Listen to me, Ms. McGriff, that what no contact means. No contact means at this point in time, absolutely no contact. No phone contact, no personal contact, no social media contact until you all are able to get this resolved in some way. I don't want you around each other, especially given that Miss McGriff is with child. Okay, so good luck to you both.
Thank you. Enjoy the rest of your day, sir.
You as well. Who do we have next?
Next, we have position number 3, Mr. Bright.
Good afternoon, Mr. Bright. You have been charged in case 25 CR 001706F with 2 counts of battery family violence. Is there a history, Mr. Howard?
Yeah, 21. 2022 disorderly conduct conviction. 2017 failure to appear. 2017 assault battery conviction. 09 FTA. He had a 08 ag assault with intent to kill conviction. 03 ag assault battery high aggravated nature conviction. And he got violence date back to the 90s.
Okay, Mr. Soroka.
Yes, Judge. This incident took place yesterday, March 31st at 954 Hightower Road, Northwest in Atlanta. Law enforcement responded in reference to a domestic dispute call. Officer made contact with the victim in this case, Miss Lillian Hunter, who explained she had gotten into a physical dispute with the defendant, her boyfriend, with whom she lives. He had gotten jealous and accused her of talking to other men on the phone. He then came up to her and struck her, causing her to sustain a cut on her cheek and a busted lip. She was able to make her way to a neighbor's house to wait for police. The defendant, upon contact with him, stated he knew that the victim was cheating on him due to her phone activities and admitted to striking her because he just couldn't hold it in anymore, and that she was hurting him by cheating on him. He was placed into custody. A little bit about those convictions. I see 2 assault and battery convictions in 93, 4 high and aggravated assault and battery convictions in 94, 95, 2000, and 2004. Criminal domestic violence conviction, 2000. These are all out of South Carolina. Assault and battery with intent to kill, as Mr. Howard stated, 2009. And just as well, public disorderly conduct, 2002. There are some other pedestrian under the influence, 2013, and public drunk, 2002. We've spoken with the victim in this case. She confirmed the events in the warrant. She stated this isn't the first time this has happened. The defendant's been violent towards her before, but this is the first time she's called the police. She says she's not in favor and is okay with having contact and with him returning to the residence, but the state will be asking for no further contact and to stay away. On the recommendation, the state is requesting a $2,000 surety on the first battery family violence count and another $2,000 surety on the second, along with anger awareness, no further contact with Lillian Hunter, stay away from that 954 Hightower Road, Northwest Atlanta address, and no drugs, weapons, or alcohol with the multiple prior arrests for intoxication and violence. We say there's a risk of reoffense here, and just a flight risk in general. Also, this happened yesterday, so there is a sufficient cooling off period for this case. We think that's appropriate. Thank you, Judge.
Mr. Chatai?
Yes, Your Honor. We ask for the lowest surety amount possible. My client is 69 years old. He has been a Georgia resident for about 10 months now. In terms of his schooling, he got through to the 11th grade and was not able to complete his GED thereafter. Currently, he's retired and he receives Social Security disability checks. And my understanding is that if he stays in jail long enough, then he risks losing those benefits. With those considerations in mind, I ask the court to consider a lower surety amount.
And it will be a $2,000 good bond on each charge, makes for a total of a $4,000 good bond. No further contact with Ms. Hunter. Stay away from the Hightower Road address. If necessary, he can go back to that address on one occasion with law enforcement to retrieve any belongings. No drugs, alcohol, weapons while out on bond. Good luck, Mr. Bright.
Next, we'll go with position number 4, Mr. DeGuge.
Yes, good afternoon, Mr. Duje. You have been charged in case 25 CR 001709J with simple assault. It's my understanding that this is his first arrest. Mr. Sirocco?
Yes, Judge. This incident took place yesterday, March 31st, 2025 at 735 Prince Place, Northwest Atlanta. It's a rooming house. Law enforcement responded there in reference to a dispute with a weapon call. Officer spoke with the victim, Mr. Mario Smith, and a witness, Mr. Maurice Williams. They explained that earlier in the day, there was a landlord had put a sign over the thermostat saying, "Don't touch it." Victim had received a text message from the landlord to ensure that that thermostat fan was set to auto, not on. So when he went to go check it, the defendant began arguing with him. Argument escalated when the defendant came downstairs. He became belligerent, yelling profanities while pointing at both the victim and the witness. The defendant then walked behind the victim, went to a closet, grabbed a butcher knife, which he then brandished at shoulder height. Victim felt in his from his perspective that if he had moved due to the heated nature of the situation, that he would have gotten stabbed. though the defendant did not make any overt movements to stab him. All witnesses there confirmed seeing the defendant with a knife at shoulder height, and stated that he did not make any overt motions to stab the victim. And there's also video evidence of the defendant holding this knife by the staircase, extending his arm, extending the knife out while and shaking that knife in his right hand. So the state is requesting, well, let me say this. We have spoken with the victim. They are roommates there at that rooming house. He's never had issues with the defendant in the past, but he stated he doesn't feel safe around the defendant, understandably so. And it's my understanding as well, the landlord doesn't want the defendant to return to the residence after this incident. Mr. Smith wants no contact with the defendant and for him to stay away. With that, the state's recommendation is a signature bond through pretrial services, no further contact with Mario Smith, stay away from 735 Prince Place, Northwest Atlanta, and no drugs, weapons, or alcohol while out on bond. Perhaps a social worker visit as well. I don't know what defense thinks about that, but that's the state's recommendation. Thank you.
Ty?
Yes, Judge. I asked the court to follow the state's recommendation for a signature bond. No objection to the no contact request. In terms of stay away, my understanding is that my client in this case and the alleged victim, they live in the same building. It's a rooming house, but they don't live in the same room. They're not roommates. So when one person lives in one room and another in a different room. If the court is not willing, though, my client did tell me that he has another place where he could live, were he to be released on bond. And apart from that, we'll go with this. We defer to the court.
Okay, it'll be a $2,000 signature bond through pretrial level 1. No further contact with Mr. Smith. Stay away from the Prince Place address. He can go back to that address on one occasion with law enforcement to retrieve any belongings. No drugs, alcohol, weapons while out on bond. Good luck to you, sir.
Next, we'll go on position number 5, Mr. Gale.
Good afternoon, Mr. Gale. You have been charged in case 25 CR 001714Y with theft by taking. I've been told this is Mr. Gale's first arrest. Mr. Sirocco.
Thank you. This is Judge. This incident took place March 26, 2025 at the 4740 Jonesboro Road Dollar Tree in Union City. The defendant was an employee there. And was observed by law enforcement taking several $100s from one of the cash registers and left the business without returning. He was caught on camera by the store manager as well. He was later located and arrested yesterday, March 31st. With that, the state's recommendation is a signature bond through pretrial services. Stay away from Dollar Tree at 4740 Jonesboro Road, and no drugs, weapons, or alcohol while out on bond.
Any objection to any of that, Mr. Chatai?
No objection, Your Honor.
All right, it'll be a $2,000 signature bond through pretrial level 1. Stay away from the Dollar Tree on Jonesboro Road. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Gale.
Next, we'll go on position number 6, Mr. Gardner.
Good afternoon, Mr. Gardner. You have been charged in case 25 CR 001676D with simple battery family violence. Told that this is Mr. Gardner's first arrest.
It is, Judge. Yes, this incident took place 2 days ago, March 30th, 2025. Law enforcement responded to 4163 Park Chase Drive in East Point in reference to a person refusing to leave call. The officer spoke with the victim, Ms. Sydney Hull. That's SYDNEY, Hull, HULL. who explained that she had been assaulted by the defendant, her boyfriend with whom she resides at the location. They were having some relationship problems, and he had physically, forcibly grabbed her by the arms multiple times to try to remove her from the residence. We've spoken with Miss Hull in regards to this case. They no longer live together, and she confirmed the events in the warrant, stating nothing like this has happened before. But she has since left the residence. She said she's not in fear and is okay having contact. We are, however, asking for no further contact and a signature bond through pretrial services, along with no drugs, weapons, or alcohol while out on bond.
Ms. Hull, I see you on the line. If you would like to address the court, now is your opportunity. You certainly do not have to, but if you would like to, I'll need for you to activate your camera. Raise your right hand for me, ma'am. If you would like to address the court, I'll need for you to raise your right hand for me. Can you hear me, Ms. Hull?
Yes.
Okay. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. What would you like to tell the court?
So he did not grab me multiple times. He grabbed me one time. I just want to make that clear. But I understand why he did. I was escalating the situation. It was partly my fault as much as it was his. I was screaming at him and I was telling him to attack me, and I should not have done that. But he said he would not. And I'm not in fear of him, and I do not want a no contact. I want to have a no violence contact if possible. And I am not in fear of him. I sound like I am, but I'm not. I'm just quite nervous right now. But I was, since having time to calm down, there was a point where I said he pushed me, but that is not true. I was closing the door on him and it was raining and he slipped and I was just standing a little too close.
Okay, so who lives at the Park Chase Drive address now?
He does.
Okay. All right, Ms. Hull, thank you for being here. Mr. Chatai?
Yes, Your Honor. My client, I don't think his background would be necessary here since the state is recommending a signature bond and no further contact, but my client is 18 years old. I reached out to his father, Mr. Quinn Gardner. He's here on the call, and he is willing to co-sign Mr. Gardner's bond if the court so requires it. And apart from that, I just asked the court to consider following the state's recommendation.
Okay, is he living on his own now?
Yes, Your Honor.
And Mr. Hayden Gardner, I don't want you answering my questions, okay? I'm directing these to your attorney here, okay? No, you're fine, so I just don't want you to get in any more trouble than you're already in. Mr. Chatai, is he working? What's the situation?
He does have a high school diploma. He graduated last year or the year before. He currently does not have a job, but he had an interview yesterday and he's actively seeking employment. I don't know about his living situation. That's not something we talked about. Right, but all I know from this is that from today is that he doesn't live with the complaining witness.
Okay. And Mr. Quinn Gardner, you're on the line with us.
Yeah, sorry about that. I was trying to get my mic working. Yeah, I'm here.
Yes, sir. Can you raise your right hand for me, please?
Yep.
Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can place your hand down. Thank you, sir. What can you tell me about your son, his living situation, things of that nature?
He's been living with us. We have a house, but he literally just moved into this apartment not even a whole 2 weeks ago. He has had a job with Waffle House. He's trying to transfer up to the location that lives where he is now, but he also works with us on a film sets as a production assistant. So he's not a violent kid. He's a really sweet kid. He's never done anything like this before. I think it was truly a misunderstanding, and we're just asking for leniency from the court any way that we can.
Okay, is the Park Chase Drive address that he's living in, are you, is that an address that you provided him? How is that working?
That's his new apartment. We live at 105 Sanders Street in Fayetteville. And so he literally just moved up into that apartment. Like I said, not even a full couple of weeks ago. So yeah, he has been living on his own. This first time getting an apartment, kind of finally getting out on his own.
Okay. Given that he's 18 years old, I'm going to have a parental cosign. I'm going to let him out through pretrial, but I'm going to require that he has a parental cosigner. Are you willing to do that?
Yes.
Okay. Is this the correct spelling of your name that's on the screen here? Quinnngardner?
That's correct.
Okay. All right. Thank you for being here, Mr. Gardner. I appreciate it.
Absolutely. Thank you.
As such, it will be a $2,000 signature bond through pretrial level 1 with a parental cosigner, Mr. Quinn Gardner. At this point in time, I don't think it's good to have these two having contact with each other, so I'm going to require no further contact with Ms. Hull at the present time. No drugs, alcohol, weapons while out on bond. All right. Good luck to you both.
Good afternoon, Your Honor. This is ACDC. Before you is position 17, Ms. Walker.
Okay, good afternoon, Officer Milton. Let me go ahead and address all the young ladies that are there in ACDC. Good afternoon. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. We're providing you with the assistance of a public defender or conflict defender if you choose to utilize their service. Ms. Walker, you have been charged in case 25 CR 001711E with simple battery family violence. It's my understanding that this is Ms. Walker's first arrest. Ms. Allen?
Your Honor, that's my information as well. And she's a dual arrest. Her co-defendant is the add-on position number 1, Mr. Hall.
Let's see. Do we have Mr. Hall in courtroom 2?
Yes, he's right here.
Okay, so why don't we just have him there, so I'll take him next. Okay, I'll be with you, Mr. Hall. Go ahead. I'm sorry, Ms. Allen.
No problem. Thank you. This is an incident at 490 Hopkins Street, Southwest Atlanta, yesterday on the 31st. Officers arrived on scene and heard a loud commotion coming from inside the home. The front gate was locked, but a few moments later, Mr. Hall, the co-defendant, came out on the front porch, and they saw him and his co-defendant, Mrs. Walker, on the front porch tussling. That's what the words used were in the documents. Police officers observed the defendant, Mr. Hull, grab Mrs. Walker by her neck and shove her down the stairs. They were told multiple times to stop engaging physically. Neither of them listened. At that point, after being grabbed by the neck and shoved down the stairs, Mrs. Walker, in front of you, began punching Mr. Hull in front of police. Both of them were separated and gave an account of an altercation that occurred in the home before police arrived. Mrs. Walker reported that she was angry. The defendant took her phone from her, and when she tried to get it back, she struck him. He grabbed her and threw her on the ground. Mr. Hull reported that he was asking her to leave, and she assaulted him because he wanted her to help clean. Neither of the individuals had visible injuries, but clearly they both reported violence inside the house, and in front of officers, they assaulted each other. So they were both arrested, Your Honor. We're asking for an SOB for Mrs. Walker through pretrial, no further contact with co-defendant Hall, to stay away from 490 Hopkins Street, Southwest Atlanta. I don't believe that's her residence. And no drugs, alcohol, or weapons.
Yes, good afternoon, Ms. McLeod.
Afternoon, Your Honor. We are okay with the signature bond. My client tells me that she would prefer no further violent contact, and the state is also accurate that they do not live together. Nothing further, Your Honor.
Okay, I believe they need a cooling off period, and since they don't live together, it will be a $2,000 signature bond through pretrial level 1. At this point in time, no further contact with Mr. Hall. Stay away from the Hopkins Street address. No drugs, alcohol, weapons while out on bond. All right, good luck to you, Ms. Walker.
Thank you, Your Honor.
You're welcome. Let's see, and this is Mr. Hall that's in courtroom 2. Who's representing Mr. Hall?
That's my client, Your Honor.
Okay, thank you. Mr. Hall, you've been charged in case 25 CR 001718F with 2 counts of simple battery family violence. Mr. Howard, is there a history?
Uh, 10 total.
Okay,
So you got an alias of Hall. 10 total, 2019 probation, 2015 FTA, 2014 trespass conviction. I don't recall seeing any violence. If it was before 2012.
okay, thank you. Mr. Sirocco, anything to add to what Ms. Allen's already told me?
No, not really, Judge. Aside from, just I would reiterate that this did happen in front of an officer, the grabbing Miss Walker by the neck and pushing her off the porch. But I would want to expand a little bit on the arrest. There was a simple battery arrest, disorderly conduct arrest in 2012. I see as well FTA in 2013. And on that criminal trespass conviction, there was a disorderly conduct and a possession of a controlled substance that I suppose would have gotten null prost. It was to the criminal trespass, so there was a conviction and some previous theft by shop convictions before that. Given the history, the state's recommending here a $1,000 surety bond on each count and no further contact with Miss Walker, Marquisa Walker, and just as well, no drugs, weapons, or alcohol, and we'll defer to the court on the matter of a stay away.
Mr. Chatai, I'm inclined to give him a signature bond through pretrial and a stay away. Do you have any objection to any, and a no further contact, any objection to that? Mr.
No,
Chatai?
no objection, Your Honor. Sorry, I was just referring to my notes. No objection.
Okay, no, you're fine. So for each charge, it'll be a $2,000 signature bond through pretrial level 1, makes for a total of a $4,000 signature bond through pretrial level 1. No further contact with Ms. Walker, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Hall. Are we going back to ACDC?
Your Honor, that concludes my business before the court. May I be excused?
Yes, Ms. McLeod. Have a good afternoon. Thank you so much.
Thank you. You're welcome.
We can go up position number 7, Mr. Hammond.
Okay, good afternoon, Mr. Hammond. You have been charged in case 25 CR 001715A with 2 counts of battery family violence. Is there a history, Mr. Howard?
2017 obstruction, NOLO, 2011 FTA, 2010 ag stalking, criminal damage to property, hindering 911 call, first offender. That's
Mr. Rocco?
Thank you, Judge. So this incident took place March 30th, 2025 at 9100 Cascade Palmetto Highway, 10E in Palmetto. I believe that's an apartment complex there. Law enforcement was alerted when the victim actually flagged down an officer at 9165 Roosevelt Highway in Palmetto. The victim, Miss Darla Pritchard, D-A-R-L-A, Pritchard, P-R-I-T-C-H-A-R-D, explained that the defendant who lived with her had kicked her door in, assaulted her during the night, and wasn't letting her leave the premises. The officer observed marks and bruises on the victim's face. She was advised to wait at a nearby BP station until emergency services arrived, which they did. And I'll get to that in a second. When officers went to the residence to make contact with the defendant, who answered the door with no signs of any violence or anything on his body, he stated that no acts of violence had transpired between them. I don't know how she got those marks. And later that day, Grady Hospital contacted the police department to advise that the victim had actually sustained bleeding to her brain as a result of this. So we've requested a felony transfer for this case. They are waiting for more information regarding the medical documentation and what the victim can provide with respect to her injuries. And on this, yes, there is an aggravated stalking conviction, criminal trespass, or criminal damage to property in the second degree, obstructing or hindering persons making an emergency phone call. That was First Offender Act Seal 2016. However, it should be noted that there was a simple battery family violence charge associated with that case that was dismissed. Just as well, NOLO to willful obstruction in 2017 with a criminal trespass and simple assault associated with that, NOLPROS. And additionally, a simple battery family violence arrest in 2010 that was NOLPROS. And I believe Mr. Howard stated there was FDA from 2011. If he didn't, my mistake. Given the nature of these injuries, which are serious, especially so, the state is recommending a $3,000 surety bond on each count. Anger awareness, no further contact with Darla Pritchard. Stay away from the apartment complex at 9100 Cascade Palmetto Highway in Palmetto. No drugs, weapons, or alcohol while out on bond. Thank you.
Darla Pritchard is on the line and wishes to address the court. Now is your opportunity. Here's Mr. Chatai.
Yes, Judge, I asked this court to consider the lowest surety amount that's reasonable to secure my client's return and to protect the community. My client is 36 years old. He was born in Georgia. He left the state and he returned a year ago. So he does have ties to the community. He has an associate's degree in psychology from the University of West Georgia, as well as Georgia Highlands University. Most recently, he worked as a rate reduction specialist for an Audi, Porsche, Mercedes-Benz in New Mexico. Obviously, he doesn't work there anymore. Since moving to Georgia, he's seeking employment here. Given those considerations, I would request this court to grant him the lowest surety amount possible.
The charge will be a $1,500 good bond, makes for a total of a $3,000 good bond. No further contact with Ms. Pritchard. Stay away from the Cascade Palmetto Highway address. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Hammond.
Next, we have position 16, Ms. Tucker.
Good afternoon, Ms. Tucker. You have been charged in case 25 CR 001710F with simple assault. Is there a history, Mr. Howard?
9th arrest. On probation in the cab for suspended license. 2022 trespass. 2017 probation. 2017 ag assault. Reduced to battery. Had a simple assault or reckless conduct with that case. Though they all were convictions. 2015 shoplifting conviction. 2014 arson, first degree, first offender.
Sally?
Thank you, Your Honor. This is an incident that occurred on February the 17th of this year, 2025. At about 7:30 in the morning, police were called to 550 Peachtree Street Northeast. There they spoke to the victim, Shantravius Youngs, who is a former co-worker. She reported that the defendant had posted threats on social media saying she would cause harm to the victim, and also threatened her in person. She had been terminated from the location where they both work, and they had asked her to leave as well, and she refused. She stayed on the property trying to fight the victim, and police were called. The victim began recording this defendant, who was seen following her, threatening her with harm. Eventually, she was able to get some help and police arrived. We did speak to the victim today, Mrs. Young. She reported that they used to work together. She thinks that the defendant assumed that maybe she was the reason why she'd lost her job. She received these threats. She confirmed what had happened and what the police report says, and that other coworkers were there and reported this incident as well to their manager. She does not want any contact. I would note, Your Honor, this defendant has a first offender conviction for arson in the first degree, and the aggravated assault in 17 SC 151892. She eventually was allowed to plead down to battery, simple assault, and reckless. Involved her slashing someone in the face with a knife. So there's a risk to reoffend and a serious prior violent history. I would argue that there might be a judgment issue here. We're asking for a $3,000 surety, no contact whatsoever with Miss Shantravius Youngs, and I believe it's Youngs, if you would sound for her. Stay away from the location at 550 Peachtree Street Northeast, and no drugs, alcohol, or weapons. Thank you.
And that's Peachtree Street. Is that the Emory Hospital?
It is.
Yes.
Okay. If Ms. Youngs is on the line and wishes to address the court, now is your opportunity. Mr. McLean, Ms. Tucker has her hand up. I don't know if you need to.
You can call 2-5215 from the desk phone.
Do you need to tell him something, Ms. Tucker, or would you want to clarify something?
Yes, I wanted to clarify something because she was saying.
Okay, Ms. Tucker, if it has to do with the incident or anything of that nature, you have a right to remain silent, and anything that you say can be used against you. If you want to clarify something in regards to the location.
Yeah, because I'm currently still employed there, just not employed with that agent. So when you say stay away, I still have a job there. I have another job. I'm in the emergency department.
Well, he had me at 5.
Okay, thank you, Ms. Tucker. Go ahead, Mr. McLean.
Your Honor, Cleo Tucker is a graduate of Forest Park High School in 2011. She is certified medical assistant. She's also working as she's also a student studying radiology at this time. She is employed at a different location, and there should, because that is a different location, there should be no trouble with any stay away. The address for mail is good. We would ask the court to consider a signature bond, and if not a signature bond, a $1,000 surety bond. Thank you.
$1,000 good bond, no further contact with Ms. Youngs. Stay away from the 550 Peachtree Street address. No drugs, alcohol, weapons while out on bond. Good luck, Ms. Tucker.
Next, we have position 8, Ms. Hemphill.
Good afternoon, Ms. Hemphill. You have been charged in case 25 CR 001716G with 2 counts of simple battery family violence. It's my understanding that this is Ms. Hemphill's first arrest. Mr. Soraka?
Yes, that's my understanding as well, Judge. This incident took place yesterday, March 31st, 2025 at 919 Gaston Street Southwest, excuse me, in Atlanta. Law enforcement responded to a call at the location, and upon arrival spoke with the victim in this case, Mr. Wydell King, who explained that the defendant, who is, I believe, his granddaughter, had been throwing multiple items at him, throwing things around the house, and pushing multiple people, including himself. This was confirmed by the grandmother as well. The victim showed the officer a video of the defendant where she could be seen with an unidentifiable object in her hand, screaming and lunging to throw said item at the victim, who was holding the camera at the time. Just as well, the victim reported that the defendant threw a Raid bottle and a perfume bottle, which hit his chest. Thankfully, it didn't leave any marks. We've spoken with the victim in this case, who has confirmed the events in the warrant. He stated that the defendant's been terrorizing everyone in the house, where she lives, they live, and that the defendant will get in his parents' face, cursing him out, throwing things. They're older individuals and they have health issues. And it's very difficult for them to consistently having to deal with the defendant acting this way. Victim doesn't want contact with him and his parents. Willie, May King, and Johnny. Those are the parents' names, and to stay away from the residence. It's my understanding that Mr. King doesn't want to be on the Zoom today, but if he changed his mind, we would ask that the court sound for him when appropriate. State's recommendation, it is a $500 signature bond through pretrial services for each count. No further contact with Wydell King. Stay away from 919 Gaston Street, Southwest Atlanta. No drugs, weapons, or alcohol. And I'm not sure how the court of defense would feel about this, but potentially social worker visit as well might be good in this case. So that's the state's recommendation. Thank you.
If Mr. Wydell King is on the line and wishes to address the court, now is your opportunity. Took your time.
Yes, Judge. No objection to the state's recommendation, and I defer to the court for any other conditions.
All right, for each charge, it will be $1,000 signature bond through pretrial level 1, makes for a total of a $2,000 signature bond through pretrial level 1, 1-day anger awareness, no further contact with Mr. Wydell King or Miss Willie Mae King, stay away from the Gaston Street address. If necessary, she can go back to that address on one occasion with law enforcement to retrieve any belongings. No drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Hemphill.
Thank you, Your Honor. Thank you, be excused.
Yes, we'll see you next time. Have a good rest of your day, Officer Milton.
Thank you.
You're welcome. Who do we have next?
We go position number 2 on the add-on calendar, Mr. Johnson.
Good afternoon, Mr. Johnson. You have been charged in case 25 CR 001719E with 2 counts of battery family violence. Is there a history, Mr. Howard?
2015 simple battery, criminal damage to property conviction. 04 robbery conviction. I stopped there.
Okay. Mrs. Rocker?
Yes, Judge. This incident took place yesterday, March 31st, 2025 at 2402 Main Street in Atlanta. Law enforcement responded to a dispute call there and made contact with the 911 caller and the victim in this case, Miss Destiny Calhoun, Calhoun, who explained that the defendant, her live-in boyfriend, had gotten into a verbal dispute with her over a vehicle. The defendant had at one point responded by walking outside, taking the stick from her possession. She was damaging her own vehicle outside. Not sure why, but the victim stated that the defendant had grabbed her, had taken her phone, and had dragged her into the house. While inside the home, he pushed her in her neck area as she was trying to get her phone back from him. Surveillance video from inside the home showed both parties re-entering the residence. In that video, the victim is repeatedly heard asking for her phone. and the defendant is seen pushing the victim and forcefully knocking her to the ground. They're wrestling on that video on the ground, and she is screaming. And after the incident, the victim exited the home, was able to use a neighbor's phone to call 911, seeing as she didn't have her own. And when the officers were able to make contact with her, they did observe visible injuries to both her neck and her arm. Just as well, no injuries were observed on the defendant. He admitted upon contact with him that he was involved in a dispute with her that turned physical. He was determined to be the primary aggressor in this situation based off of the surveillance footage and what they were able to gather from the situation in speaking with both parties. I see two. I'm wondering if it's a duplicate on that. It's a robbery causing serious injury, 2004 in New York. But I see two of those there. There were some other arrests there for robbery and forcible thefts armed with a deadly weapon and criminal possession of a weapon with intent to use, neither of which he was arraigned for. In Georgia, simple battery conviction, criminal damage, and trespass to property in the second degree. Criminal damage to property in the second degree, 2015. You see parole violations in 2016. He was confined 6 years for that, and just as well, fleeing and eluding theft, felony theft by receiving, transport, possession, firearm by convicted felon. 2016, that was dismissed. Disorderly conduct arrest, criminal trespass arrests in 2017 and 2021 respectively. And there is the open case, purchase, possession, manufacture, distribution, sale of marijuana, and 2 counts of possession of cocaine with intent to distribute. That's 24 SC 001 355. He actually FTA'd for that case on November 8th. There was a 2024 hearing. That bench warrant was set aside a few weeks later, I should note. We have been in contact with the victim. They are in a relationship. They live together at the location, and they don't share any children. She's confirmed the events in the warrant, stated nothing like this has happened before, and that she's not in fear, wants to continue contact, and that she will be on Zoom. So we would ask that the court sound for her when appropriate. The state is requesting a $1,500 surety bond on each count. Given the risk of the offense here, the open cases being on bond, and just as well anger awareness, and no further contact with Destiny Calhoun. Stay away from 2402 Main Street, Atlanta, and no drugs, weapons, or alcohol while out on bond. That is all. Thank you.
Ms. Calhoun, I see you on the line. If you would like to address the court, now is your opportunity to do so. I would need for you to activate your camera, unmute yourself, and I'll have to swear you in if you choose to address the court. Yes, ma'am. If you can raise your right hand for me, please. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down, ma'am. What would you like to tell the court?
I would actually just like to say that this is the one time I had an event. I've never had an altercation that spun out of control as such. With Mr. Johnson, we are in a relationship. We do reside with each other. Again, he's never been violent towards me before. We've never got into any physical altercation prior to this. I feel as though he is a good man, a good dad. I don't have any issues. I did speak to the solicitor already, and I did also let her know that I do not have any fear of Mr. Johnson. I do not fear for my life or my safety around him or in his presence. And I do not wish to pursue any legal action against him. I do not wish to press charges. I don't, like I said, I do feel like this was a one-time incident, and I do feel as though, even though the officer named him as the primary aggressor. I will say that I did agitate the situation more than what it was, because it did start off as a verbal just disagreement, and I did allow my emotions of the verbal disagreement to get the best of me, and I reacted in anger. I will say that Mr. Johnson, in reaction to my anger, did respond in anger. And so I don't hold any hostility or any anger against Mr. Johnson. Like I said, it's just a one-time incident. We both let our anger get the best of us. I do not wish to pursue any legal actions against him, and I'm not afraid of my life.
Okay, during the incident, did you put any hands on him?
Yes, I did.
And did he place hands on you? What did he do?
I was retrieving my phone, and Mr. Johnson was simply trying to separate himself. I don't wish to press no charges. I don't, just a one-time thing. And
Okay,
yeah.
you've already told me that, but I want to know what happened. Tell me what happened.
I don't wish to go into much details. I will tell you the basic. We got into a verbal altercation about who would be driving the vehicle. I was upset that he was leaving the property. I went outside, attempted to damage my own vehicle. At the time, Mr. Johnson was a little bit upset that I was doing that, so he did come outside to interfere. I dropped my phone. Mr. Johnson ended up with my phone, and I was upset, so I attempted to get my phone back, of which he did attempt to separate himself from me, and I aggravated the situation a little bit more than what it could have been. Once I was able to get my phone, I did run down the street and call for assistance, only because I felt like I just wanted someone to be here while I retrieve my items, as we were both leaving the premises anyway.
I have a
All
question,
right,
if you don't, Judge.
go ahead, Mr.
Did he push you to the ground in that exchange?
I can't tell you specifically like what motions were done. I just felt like a push and a shove. I can't tell you if it was really a push or a shove, but I felt hands and I just reacted.
And did you fall on the ground?
Yes, I did. We both fell on the ground.
Thank you. No further questions.
Thank you for being here this afternoon, Ms. Calhoun.
Thank you.
Mr. Chitai?
Yes, Judge, I asked the court to consider the lowest surety amount that's reasonable for my client. He's 38. He's been a Georgia resident for the past 15 years. He has strong ties to the community. He has a GED, and he also has stable employment. He's been working at Big Heart Wildlife Removal for the past 45 years, and he removes unwanted animals from homes.
Okay, Mr. Johnson, you have a right to remain silent. Anything you say can be used against you. Quite often people want to tell me something and they'll get themselves into more trouble, but I see that you have your hand up there. And Mr. Chitai, do you want to address him?
Yes, Mr. Johnson, is this a question about the bond proceeding itself, about the procedure? Because I strongly recommend you don't talk about the case.
It said that I have 2 counts of battery. I have 1. And 2, I don't have two robberies from 2004, whatever my history. I only had 1 robbery in 2004. I never had 2 ag guns. I never had any of those charges.
All right.
So
another attorney will be able to answer those questions at a later date. We can't address those right now since this is just a bond hearing. Okay.
So I'm being charged with 2 batteries because I'm not. Oh, you said 2 counts.
Again, another attorney will address those for you. Okay, we're not at the stage where we can do anything about those.
In this case, Mr. Johnson, you are charged with 2 counts of battery family violence.
How? I'm trying to understand how, but I have 2 cases of that. I have 1 on my paper, and I was only charged with 1. So where was the second one coming from?
Is there an add-on charge, Mr. Shiraka?
There is, Judge.
Okay.
One was for the dragging, and the other one was for the shoving.
Okay. That being the case, it will be a $1,500 good bond per charge, makes for a total of a $3,000 good bond. I don't think it's good for either of these young people to be around each other at the present time. So at this time, no further contact with Destiny Calhoun. Stay away from the Main Street address. He can go back to that address on 1 occasion with law enforcement to retrieve any belongings, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Johnson. Who do we have next?
Position number 18, Mr. Williams.
Good afternoon, Mr. Williams. You have been charged in case 25 CR 001713D with battery family violence, simple battery family violence, and theft by taking. So history, Mr. Howard.
Fourth adult arrest on probation in Clayton County, terrorist threats. 2014 larceny, 09 theft, obstruct, conviction. Arrest, I'm sorry. That's it.
Thank you, Ms. Allen.
Thank you, Your Honor. This is an incident from September the 13th of 2024, so warrant that's been active for a period of time. Police were called to 2722 Lancaster Drive in East Point. There they spoke with the victim about a fight that they'd been called to the location about. She was observed to be crying. Her name is Ashley Session. She said the father of her child had become upset because she went out without him for the evening. When she got home, he damaged items in the car or in the home and then took her car. She said that he grabbed her by her neck and pushed her against a wall and that he was locking her out of the house. The victim reported that the defendant stole her car, and officers challenged that, basically asking, he gets to use it sometimes, correct? And the victim actually said, well, he's not allowed to use it right now, and he took my keys from me, and I don't know where he's going. She reported that this was not the first time the defendant had been physical with her. He'd also taken her glasses. She had red marks on the center of her face where he had made contact with her face by shoving her. We did speak to the victim today. She reports that she and the defendant are no longer in a relationship. They don't live together, but they do share 2 children. She confirmed what had happened. She said both of his hands were around her neck at one point, applying pressure. She did not feel she was going to lose consciousness. And this is not the first time that he's been angry and destroyed property and been violent. She said it took her 2 days to get her phone back, that they have had some contact since this, and there's been no violence since. She did report, of course, they're no longer living together, so there doesn't need to be a stay away, Your Honor. The defendant has prior history and arrests, including juvenile dispositions for violence and terroristic threats, and arrests out of Alabama. We're asking for a $5,000 surety and no contact with Mrs. Sessions, third party transfer of the children if necessary, no drugs, alcohol, or weapons.
If Ms. Ashley Sessions is on the line and wishes to address the court, now is your opportunity. Mr. McLean.
Thank you, Your Honor. Lee Williams is a Georgian. He has an Associate of Arts degree in information technology, 2-year degree. He's only 6 credit hours short of a bachelor's. He's nearly there. He works for a large transportation company headquartered in Atlanta, a Fortune 500 company. And before that, he's done that for 3 years. Before that, as a CDL and did over-the-road trucking. This is, of course, from September. Hopefully there's been no problem since. Based on all the above, we asked the court to consider a signature bond. And if not that, then a $1,000 surety.
Okay, for the battery, it'll be a $1,000 good bond. For the theft, a $500 good bond. For the simple battery, a $500 good bond. Makes for a total of a $2,000 good bond. No further contact with Ms. Sessions. Third-party transfer of any minor children for visitation. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Williams.
Next, we have position number 9, Mr. Mallory.
Good afternoon, Mr. Mallory. You have been charged in case 25 CR 001700G with 2 counts of simple battery, family violence, and criminal trespass. Is there a history, Mr. Howard?
10. Got an open case out of state court, simple battery DV. It's 21 CR 005-154G. Got an open case again, 24 CR 002-996G, simple battery family violence. 2022 probation, 2020 ag assault, obstruction first offender, 2014 battery arrest, 09 simple battery. That's
Thank you, Ms. Allen.
Thank you, Your Honor. So this is an incident from yesterday. The location is 8207 Colquitt Road, Apartment A in Atlanta. That's the location where the defendant lives with his mother and a brother. His mother is Mrs. Althea Scott Mallory, and his brother is Emmanuel Okwunze. They are both either witnesses or victims in prior cases, Your Honor. Police were called to the location there, and police spoke with the brother, Mr. Okwunze, who said he witnessed his mom be struck by the defendant in the face. The defendant also struck his brother, and that was in front of mom. This all occurred because the defendant became upset when they woke him up for work and told him he needed to get up. His brother was assaulted first, went to his bedroom to try to get away from the defendant, but the defendant forced his way into the brother's room, actually removing the door from the hinges and striking him in the face. Mom tried to intervene, and at that point, the defendant began striking his mother in front of his brother and pushing her out of the way. Police observed the damage there on the scene. I would note that the two open cases, Your Honor, 21 CR 005-154G is a very old case that was in Orca and then transferred back to the division, is a open simple battery family violence, again, against mom Althea Scott Mallory. He's on bond and required to have no violent contact with her. And then he's got a May 2024 arrest, which is a simple battery against a woman he shares a child with, Tiara Weston. That was also in front of the court in Orca. He is out on bond issued by you, $1,000 good bond from May, ordered to have no further violent contact and obviously to have no further violations of the law. I would note that both of his open cases include facts that state he was under the influence, and both of his bond orders include requirements that he not drink or do any drugs or be in possession of any weapons. And so he's in violation of two bond orders on two open cases and has had violent contact with his mother and assaulted his brother. That's separate from the other criminal history he has, but I'm not going to go into those things. At this point, we're asking for, let's see, we'd ask for a $8,000 surety bond, Your Honor, no contact with either Mrs. Althea Scott Mallory or Emmanuel Okwunze, Okwunze. To stay away from that location, 8207 Colquitt Road, Apartment A. No drugs, alcohol, or weapons. Thank you. We have not been able to get in touch with the victims in the case today, but we'll continue those efforts.
Okay, if Ms. Mallory or Mr. Emmanuel, either on the line and wish to address the court, now is your opportunity. Mr. McLean.
Your Honor, thank you. Jabari Mallory is a graduate of North Springs High School. He works for one of the very large farmers markets, essentially it's essentially like a mega grocery store. So he works in the butcher department as an assistant and a technician. And then he's done that for 3 years now. Before that, he worked for a large national chain as a grocery store. We'd ask the court to consider the lowest bond that would be reasonable. In this case, we would suggest if a signature bond, or if that's not possible, then, Your Honor, we would ask for a $1,000 to $2,000 surety.
Okay, for each of the simple batteries, it will be a $2,000 good bond. For the criminal trespass, $1,000 good bond. Makes for a total of a $5,000 good bond. No further contact with either Ms. Mallory or Mr. Emmanuel. Stay away from the Colquitt Road address. If necessary, he can go back to that address on one occasion with law enforcement to retrieve any belongings. Given that this is his third family violence allegation, I'm going to order family violence intervention program. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Mallory.
Next, we'll go position number 13, Mr. Moore.
Good afternoon, Mr. Moore. You have been charged in case 25 CR 001717C with obstruction of law enforcement officers. Is there a history, Mr. Howard?
Second, 2019 DUI.
Ms. Allen?
Your Honor, this is a bind over, so the defendant in front of you has had a first appearance, and his case was bound over. He's got a $1,000 surety bond. This is an incident from March the 28th at 5750 Buffington Road in Union City. Police were on scene there investigating an aggravated assault, and the crime scene was blocked off using yellow tape. The defendant was instructed to stop and not cross through the crime scene. He disregarded that, breached the crime scene barrier. Again, was told he couldn't just walk through the crime scene. He shouted loudly, "I'm just trying to go home." And he refused to comply with officers. He became irate and ultimately had to be arrested. We're asking for a $1,000 surety, Your Honor, that he already has, no drugs, alcohol, or weapons. Thank you.
Your Honor, he does live on Lantos Place in Atlanta. He's got a good address. He went to Mays High School, and then he went to a college here in Atlanta and also a college in Northeast Georgia. He works for the last 7 months at an auto part warehouse and worked at a different warehouse before that, and has had various employments. He's very industrious. He's a food company and a glass company. We would ask the court to consider a signature bond. If that's not possible, then $1,000 surety.
Okay, it'll be a $1,000 signature bond through pretrial level 1. No drugs, alcohol, weapons while out on bond. I'm going to let you out, Mr. Moore, but you're going to have to make sure to show up for your next court hearing. Otherwise, they're going to put a warrant out for you, okay? All right, good luck to you, sir.
Next, we'll go positions number 14 and 15, Mr. Roebuck.
Yes, good afternoon, Mr. Roebuck. You have been charged in case 25 CR 001653F with battery and simple battery, and in case 25 CR 001658F with criminal trespass. Is there a history, Mr. Howard?
16, resident of Shreveport, Louisiana. Has a bench warrant, open bench warrant. Open case in Superior Court, criminal damage to property, 2nd degree. 24 PI 006987. Open case out of Louisiana, resisting an officer. Remaining in places on land after being forbidden. I guess it's trespass. 2023 resisting. 2017 assault on family member conviction. 2014 simple battery conviction. 2014 battery 2nd degree conviction.
Thank you, Ms. Allen. Thank you,
Thank
Ms.
you.
Allen.
Your Honor, this first position number 14 on the calendar is a battery and a simple battery. This is an incident from January the 9th of 2025 at about 8 p.m. Police were called to 5155 West Park Drive Southwest. They spoke to the general manager there of the Novo Healthcare location. His name is Mr. Mitchell. He reported that 2 temporary employees had engaged in a physical altercation. They were both outside on break at about 8 p.m. smoking. He also reported that there was surveillance camera footage of a portion of the incident. Witnesses on scene reported that they were present and nearby. when the defendant approached the victim as he sat at the table and started screaming at him. His name is Mr. Rhodes. The victim in this case is Clinton Rhodes. So the defendant approached him, began screaming at him, then pushed him to the ground where he started punching him repeatedly in his face and kicking him all over his body. The victim was screaming for help, and it's that portion where he's screaming for help and on the ground and flees with the help of other employees there to get help that's captured on surveillance. The victim had bruising to the left side of his face and above his right eye, as well as swelling. The defendant had fled the scene, but warrants were obtained. He does have criminal history out of Louisiana, Texas, and Georgia, including assaults on police as well as family members. He also has a failure to appear March the 30th of 2025. We're asking for a $4,000 surety bond. We did speak to the victim, Mr. Clinton Rhodes, yesterday. This case was reset from yesterday. He said that he and the defendant were co-workers and they'd never met prior to this incident. He has no idea why he was assaulted, and he no longer works at the location, so there's no stay away needed. Your Honor, this is a person with a very violent past who has more ties to other states than to Georgia, and so there's a concern not just for risk to reoffend based on his history, but a flight risk based on not having a lot of ties to Georgia. No contact, no drugs, alcohol, or weapons, and we'd ask for that $4,000 surety, Your Honor. Thank you.
And position 15, Ms. Allen.
Sorry, go ahead. Position 15 is when the defendant was arrested on the 29th. He was on MARTA at the 5 Point Station, which is 30 Alabama Street. He was seen inside the station and identified as a person who they had issued a 365-day ban to. He was known to the officers there. He'd been banned from MARTA on September the 20th of 2024. So he's got a criminal trespass for that. And when he was arrested, it was seen that he had this outstanding warrant. We're asking for a $1,000 surety on that case and to stay away from MARTA, no drugs, alcohol, or weapons.
Thank you. Mr. McLean.
Thank you, Your Honor. Mr. Roebuck has went through the 8th grade and then went into Job Corps to finish his education. And after Job Corps, based on the skills he learned there, he was able to get jobs in construction and delivery. And as we heard, he worked in a temporary job. So he's an industrious person. Your Honor, we would ask the court to consider the lowest possible surety bond. If a signature bond is not possible, we would ask $1,000 surety.
Okay, position 14, the battery, a $2,000 good bond. The simple battery, a $1,000 good bond, makes for a total of a $3,000 good bond. No further contact with Clinton Rhodes. No drugs, alcohol, weapons while out on bond. Position 15, criminal trespass, $1,000 good bond. Stay away from MARTA. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Roebuck.
Next, we'll go position. Hold on.
All we got is 12, right?
Yeah, position number 12, Mr. Miles.
Yeah, that's it.
Good afternoon, Mr. Miles. You have been charged in case 25 CR 001703C with criminal trespass and damage to property, battery family violence, and 2 counts of simple battery family violence. Is there a history, Mr. Howard?
And the rest, forgery from 2024 out of Henry County. I got an open possession of a Schedule 2, 24 SC 001858. Armed robbery, ag assault, possession of a knife or a firearm during the commission. Battery, it shows open in Odyssey, 23 CP 222857. 2018 ag assault, criminal damage to property, armed robbery dismissed. 2017-18 failed to appear. Has a bench warrant and went to felony earlier, and I was told it was no bond. So that's it.
Alan?
Thank you, Your Honor. This is an incident from yesterday, the 31st of March. Police were dispatched to 388 Legacy Drive, Southwest, specifically apartment 912, excuse me. At the location, they found the door open. They spoke to the victim, Mrs. Shakiria Hooten. She said she was unaware the door was open, but that her boyfriend, the defendant, had taken her keys, packed a bag, and taken her car. He wouldn't return it to her, and he told her to call the police. Her keys were on the front steps, so officers advised the victim to call the defendant and ask him if he was returning to the location. He came, and Mrs. Hooten reported that he'd kicked in her door, walked up the stairs, and grabbed her by the back of her hair, pulling her down a flight of steps at the residence, and then punched her with a closed fist. During an altercation, he used his hands to wrap around her neck and apply pressure. And she had injuries on her neck when she met with police. They observed damage to the door, as well as the injuries on her. So this is an incident that occurred over a period of time, leaving the location and returning again. Ultimately, police there on scene witnessing the aftermath. We did speak to Mrs. Hooten. She reports that she and the defendant share 5 children. And they were at the top of the stairs when this occurred, having a disagreement, and he grabbed her by her hair and they fell down the stairs. She denies she was ever punched or choked. And this may be because they're having conversations from the jail and are really more concerned with the open felony cases, Your Honor. The defendant you just heard has new felony charges that he was on first appearance for today. But he also has an open armed robbery and a failure to appear from this month. We're asking for a $7,000 surety to stay away from 388 Legacy Drive Southwest, apartment 912. No further contact with Mrs. Hooten and family violence intervention programming or anger awareness. No drugs, alcohol, or weapons. And I believe Ms. Hooten is here. After she said she wasn't sure how she sustained injuries to her neck and denied that she'd been assaulted, there was no real reason to ask about her car and the other things that she'd reported as it led up to that incident. But please sound for her. Thank you.
Ms. Hooten, if you would like to address the court, now is your opportunity to do so. I need for you to raise your right hand for me, please, ma'am.
Yes, sir.
Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Okay, you can place your hand down, ma'am. What would you like to tell the court?
Just basically, what I told the solicitor earlier today. We was having a disagreement about something, and I tried to move him out the way, well, technically push him out the way, and we was by the steps. Like I explained to her, he was already clearly by the edge of the steps. So as him being there and I pushed him, he was finna fall. I have long hair in my head, which is tied up. So as he tried to grab my shirt, he also grabbed my hair. When we finally got to the bottom of the steps, because it's 2 flight of steps, I realized that my hair had came out when he was put, which kind of made me angry. So then I asked him if he could just leave. I called myself calling the police, which some of the stuff that I did tell the officer was to try to get them to come quicker, to kind of scare him so he could just leave. But I ask that you all take in consideration that we have 5 kids together. My youngest is 2. We have 3 boys. One of my boys have a condition where he is back and forth in the hospital. Their dad is also the only support I have financially and physically. My son has seizures and also kidney problems, which his kidneys now is dropping to 73%. And we both kind of take turns, and my youngest daughter look for him every day. So I just ask that you all take in consideration of that because he's the only support that I have.
Okay, thank you, Mr. Hooten. I appreciate you being here. I'm sorry to hear about your child, ma'am.
Thank you.
Mr. McLean?
Thank you, Honor. 30 years old, Mr. Miles has graduated from Benjamin Mays High School and has worked in security, has worked as a caretaker in-home, and has had several other types of jobs. He works. Your Honor, we would ask the court under these circumstances, given what we've heard, to set the lowest possible bond, if that would be a signature bond, but if not, a $1,000 or $2,000 surety bond.
Okay, for the criminal trespass, it will be $1,000 good bond. For the battery, a $2,000 good bond. For the simple battery, each of them $1,000 good bond, makes for a total of a $5,000 good bond. At this point in time, no further contact with Ms. Hooten and stay away from the Legacy Drive address. No drugs, alcohol, weapons while out on bond. Mr. Miles, I will see you back personally on April 15th at my SAP calendar, and I will speak with the attorneys at that point regarding this matter. Good luck to you all. All right, does that conclude the 2 o'clock calendar? I believe so.
Yes.
All right. So, Ms. Bridgewater, whenever you're ready.
Okay, once again, the reset date for the SAP calendar is going to be April the 15th. Position number 1 is reset further notice with a $1,000 SOB through pretrial. Position 2 is reset further notice with a $1,000 SOB through pretrial. Position 3 is going to the SAP calendar with a total $4,000 good bond. Position 4, reset further notice with a $2,000 SOB through pretrial. Position 5, reset further notice with a $2,000 SOB through pretrial. Position 6 is reset further notice with a $2,000 SOB through pretrial with a co-signer of Quinn Gardner. 7 is going to the SAP calendar with a total $3,000 good bond. 8, reset further notice with a total $2,000 SOB through pretrial. 9, SAP calendar with a total $5,000 good bond. 10, reset further notice with a $2,000 SOB through pretrial. 11, SAP calendar with a total $1,000 good bond. 12, SAP calendar with a total $5,000 good bond. 13 is reset further notice with a $1,000 SOB through pretrial. 14 is going to the SAP calendar with a total $3,000 good bond. 15 is going to the SAP calendar with a $1,000 good bond. 16, SAP calendar with a $1,000 good bond. 17 is reset further notice with a $2,000 SOB through pretrial. 18 is going to the SAP calendar with a total $2,000 good bond. On the add-on calendar, position number 1 is reset further notice with a total $4,000 SOB through pretrial. And position 2 is going to the SAP calendar with a total $3,000 good bond. Are there any questions, comments, or otherwise?
Okay, now, thank you all. I will see you next time.
Thank you so much, everyone.
Thank
Take
you,
care,
Judge.
everyone.
Thanks, guys.
Bye-bye.